Welcome to the Agony of a Missed Deadline, or Was That Deadline Really Missed? Sponsored by the ABA section of Taxation. We are joined on the program today by Elizabeth Maresca, Sheri Dillon, Drita Tonuzi, Carlton Smith, and Keith Fogg. Elizabeth is a clinical professor of law at Fordham University School of Law and supervising attorney of the Civil Litigation Clinic. She has also taught income taxation and lawyering skills and is located in New York, New York. Sheri is a partner with Morgan, Lewis & Bockius, LLP, focusing on federal tax controversy matters, guiding clients through IRS examinations and appeals, the administrative claims process, and litigation. She's located in Washington, D.C. Drita serves as the Deputy Chief Counsel of Operations for the IRS in Washington, D.C. In this position, Ms. Tonuzi provides legal guidance and litigation support to the Internal Revenue Service, IRS, and the Departments of Treasury and Justice in all matters pertaining to the administration of tax law. She's located in Washington, D.C. Carlton worked as an associate and partner at Roberts & Holland, LLP in Manhattan from 1983 to 1999. From 2003 to 2013, he was the director of the Cardozo School of Law Tax Clinic. In his retirement, he volunteers with the tax clinic at Harvard, where he was acting director from January to June 2019. He is located in Boston, Massachusetts. Keith directs the Federal Tax Clinic at the Legal Services Center, where he serves as a clinical professor of law. He joined the Harvard faculty in 2017 after teaching at Villanova Law School for a decade. He is located in Jamaica Plain, Massachusetts. Please proceed with today's program.
All right, everyone, I have the pleasure of starting. And Michelle, for your benefit, we already have a question out there that there may be an audio issue because the person is hearing both background music and talking. So I'm going to let you deal with that. Welcome, everyone, and we're very pleased that you were able to join us. We are at 298 listeners and counting, and I know that many of you out there are from the Office of Chief Counsel. So I send you a particular hello and welcome. So as you may know, the code section 7508A was designed to provide relief in the case of major disasters. And it allows the Secretary of the Treasury to effectively disregard or postpone deadlines for a period of up to 1 year following a disaster declaration under Code Section 165I5 Cap A. As it relates to COVID, the COVID-19 pandemic, the President declared a national emergency under the Stafford Act on March 13, 2020. And in that declaration, there was no specific reference to the start of the emergency. And it's important to note that that was an emergency declaration, not a major disaster declaration. But since then, the President has declared major disasters in each and every state, in D.C., in 4 territories, and with respect to 32 tribes. And these declarations, contrary to the emergency declaration of March 13th, do indicate that the pandemic began on January 20th, 2020, and that is a fact that Starry will be addressing shortly in the program. So the IRS recognized the need for speed and flexibility to address this pandemic and began responding to the emergency first by issuing notice 2020-18 invoking 7508 Cap A with respect to the postponement of payments due with respect to returns due on April 15th. And that was issued on March 18th, shortly after the declaration of the emergency. Then on March 27th, we expanded the relief to include not only the payment, but also the filing through notice 2020-20. And then finally, the notice that we're here to talk about, notice 2020-23, was issued on April 9th, and effectively and significantly amplified the relief from 7508 Cap A. As it relates to this program, though, it postponed a variety of due dates relating to tax court petitions. And it postponed those dates to July 15th for petitions that were due on or after April 1st. So at the time that we were drafting this notice, we were obviously mindful of the Grauman case, which effectively provides similar relief for petitions that are due after the court clerk's office is closed. And that case we'll talk about in a little while. It's the Snow Day case by the name of Grauman. But, there still remain some uncertainties about the full impact of the 7508 Cap A relief that Sheri will discuss shortly. Now, Sheri, I'm going to turn the speaker to you. So if Keith can help us advance the slide, and Sheri, if you want to jump in at this point.
Great. Thank you, Drita. And I think, like all practitioners, also want to extend our appreciation to you and to all of the IRS attorneys and other employees on the phone, as well as those not on the phone, for acting with such speed. And the dedication and commitment I've seen has been unparalleled. We also really appreciate the Secretary and the IRS exercising their authority under Section 7508A, and specifically under Cap A and Paragraph A. One of the things that I wanted to chat about today is something that a lot of folks may not be aware of, and that is of Section 7508 Cap A, Section D. Some of you might be saying, wait a minute, that's not in my code. Well, actually, it was a new section that was enacted on December 20th, 2019. I know if you're operating, I always bring home my last code whenever I get a new code in the office, and my old code doesn't have it. But when you Google it, you will find it on the internet. And a question is, well, what is it? I've told you where it can be found, and what does it do? Well, what it does is it's a new code section that was enacted because the House believed that certainty and additional time should be provided by an automatic extension of certain filing deadlines for taxpayers affected by federally declared disasters. And that's exactly what it intends to do. It's a mandatory 60-day extension with respect to federally declared disasters. And the way the statute appears to operate, again, it's a brand new provision, so we're all learning about it, but it tells us that in the case of any qualified taxpayer, the period beginning on the earliest incident date specified in the declaration to which the disaster area referred to in paragraph 2 is the beginning of the period of this mandatory 60-day extension. And there's a lot to unpack there, but and I'll get to qualified taxpayer. That definition, when you have a chance to look it up yourself, you'll see it's a very broad definition, and it seems to capture nearly every taxpayer currently in the United States. And again, I said in the United States because I'm not sure if it actually captures taxpayers residing outside the United States, but the definition is very broad, and it happens to be, in this case, we determine which ones are qualified by looking to where the federally declared disasters were declared. And I think, as Drita mentioned, every state, every territory, as well as Indian tribes, were declared there was a major declaration, a major disaster declaration for each and every state. So it seems to put, as well as the other categories. So it seems to make pretty much everyone in the United States a qualified taxpayer. And the declaration, which if you're looking for the declarations, I should point out, they are on the FEMA website. That's where you find them. And you look up FEMA COVID-19, you can find the disaster declarations, and then you'll see one there for each and every single state, as well as the tribes and territories. So it tells us who's covered. It tells us, where you reside or where the disaster areas are, referring you to what's been declared a federally declared disaster area. And it tells us that it begins on the earliest incident date specified in the declaration, which here is January 20th. So a question is raised then, if this mandatory extension starts on that date, which is January 20th, that is obviously in advance of the April 1st date that was provided for Notice 2023. Now it tells us, and that raises an interesting question then, are all deadlines for affected taxpayers, meaning the qualified taxpayers, therefore mandatorily provided an automatic extension of any of their deadlines that the Secretary specified in his notice, again, Notice 2023. When does it end? When would this automatic period end? Well, it ends 60 days after the latest incident date so specified. Currently, the way the disaster declaration reads is it is continuing. So there is no end date yet. And it raises, again, interesting questions as to whether that could go past the July 15th date, or could it end sooner, and the interaction between the notice, Geralnik, as well as this particular code section. So again, what we're seeing is that the intent appears to be to supplement the actions of the IRS, that it could be either current or it could be additional time provided for those who may have missed deadlines and that were affected. And again, we know that all taxpayers are affected by the COVID-19 emergency pursuant to the disaster declarations. And this is a brand new statute. It has not been interpreted yet, and so everyone should read it carefully. There's not very much legislative history, but it seems to be, pretty plainly worded. And I think it would be a matter of statutory interpretation up to Chevron, a Chevron-type analysis to determine exactly what does this mean. But it does appear to mean that perhaps all deadlines were extended starting January 20th. Drita, I don't know if the IRS has a view on this.
Well, so I think an important thing to note here is that when this new D provision was enacted on December 20th of 2019, we did not have an equivalent disaster like the COVID emergency. Before that date, the disasters that were covered by 7508 Cap A were localized, hurricanes, tornadoes, and maybe even regionalized, but nothing on the scale of a national disaster as we are currently facing. So it's unclear what Congress really intended at that point in time. But we recognize that this provision does raise issues, and we are going to very closely evaluate and address it. And of course, as it relates to tax court petitions, we will respond appropriately, and we recognize that there are unique challenges that this new statute presents to taxpayers. And of course, we've received your input, Sheri, but we're also open to receiving input from others. And I apologize if there's feedback here.
No, Drita, that's very helpful. And again, everyone should be looking at this closely themselves, given that it's brand new. We're all sorting through it, and especially for folks, I know myself, I was not, didn't have expertise in disaster relief. So you have to do some digging, but it's something everyone should look into, particularly if they inadvertently had a missed deadline for one of their taxpayers. And I turn it back to you, Drita.
Okay. Yeah, thank you. So Keith, if you wouldn't mind advancing the slide to the next slide. Okay. So now we have an example under 7508 Cap A, subsection A. So we're going to set aside B for the moment. So in this example, a statutory notice of deficiency which was issued on Wednesday, January 15th, 2020. The normal petition due date for this stat notice would have been April 14th, 2020. Our notice, 2020-23, postponed under this example the due date from April 14th to July 15th, 2020. Just a plain reading of our notice and the time frame provided in the notice.
Okay, thank you, Drita. So I'm going to just talk a little bit about the closure of the tax court, and that term in the top of the slide is a little bit of a misnomer because the tax court itself is not closed. The judges are still working, but pieces of the tax court have closed down, and we outline that in the timeline of notices from the court in terms of what was happening. So on March 11th, the court begins to cancel calendars. A couple of days later, it cancels more calendars, and it closes the building to visitors, but the clerk's office was still operational. Then 5 days later, on March 18th, the tax court, closed the building until further notice, and the clerk's office closed down at 9 o'clock that night. And then on March 23rd, the tax court canceled all the spring trial calendars. So it's not just because it's canceled all the spring trial calendars, that's not necessarily going to be coextensive with when the clerk's office reopens. And as you'll learn in the discussion coming up about Geralnik, the clerk's office being open or closed is going to be the critical time period. So right now, the court building is closed to visitors, the clerk's office is closed, but the court is still operating. So if you have a deadline to file a brief or to respond to a motion, those deadlines are not being impacted by what's happening, but you cannot get things into the clerk's office, and that's going to affect the discussion that Elizabeth is going to provide for us now.
Hi, everyone. This is Elizabeth Maresca from Fordham Law School. I'm going to just start by giving you the facts of the case of Geralnik v. Commissioner. So the taxpayer's petition, it was a CDP case, was due on Sunday, February 15th. That was the 30th day. And then Monday, February 16th, was President's Day. So under Section 7503, the petition was due on Tuesday, February 17th. And Tuesday, February 17th happened to be declared a snow day in District of Columbia. For those of you who don't know the District of Columbia, a snow day in the District of Columbia is when there is one snowflake floating somewhere over the state of Virginia. But anyway, the clerk's office was closed all day on Tuesday, February 17th because of the snowstorm, and it did not reopen until Wednesday, February 18th. So the taxpayer on the Friday before mailed his petition to the tax court by FedEx first overnight, which at that time was not a designated delivery service under Section 7502, which is the timely mailing is timely filing law, statute. So the court was closed on the day again due to the snowstorm, and FedEx could not effectuate delivery because the clerk's office was closed, the building was closed. So on the next day, on Wednesday, February 18th, the FedEx delivered the package, and the clerk filed the petition on that day. And the IRS moved to dismiss the case because the petition was filed 1 day late. Okay, so the court's holding was that Section 6330 is jurisdictional and not subject to equitable tolling. But that Tax Court Rule 1B states that when the Tax Court Rule does not contain an applicable rule, they will give weight to the Federal Rules of Civil Procedure. And the Federal Rule of Civil Procedure, 6A, postpones the due date of any act to the first accessible day. If the clerk's office is closed, it postpones the due date to the first day where the clerk's office is accessible. That's not a Saturday, Sunday, or legal holiday. So because the clerk's office was inaccessible on Tuesday and it reopened on Wednesday, the court ruled that the due date for the petition was actually Wednesday, February 18th. Okay, so if we apply Geralnik to some facts that we have here, we will see that in our example, a statutory notice of deficiency was issued on December 31st. So the petition due date would be Monday, March 30th. Now, the tax court's clerk's office was closed on that day, so we believe that the taxpayer is going to get the benefit of both Goralnik and Notice 2020-23 because the clerk's office was closed on March 30th, and 2023 extends the date for anything that has to get done between April 1st until July 15th. So if the tax court if the tax court reopens before July 15th, then 2023 still applies until July 15th. And if the tax court reopens after July 15th, then the taxpayer is going to get the benefit of the notice 2020-23 and Goralnik, and then it will have to file the petition the first day that the clerk's office is accessible.
So, Elizabeth, just to clarify, because the notice only covers through July 15th and Goralnik covers until the day that the court becomes accessible, in your last example, the notice does not apply at all.
Okay, thank you for that clarification, Drita. That's certainly very helpful. And again, just as a practice note, we understand that the court is not receiving mail. I don't know how it is for everyone in the audience, but we're having a lot of trouble with mail in New York City. Sometimes it's not getting delivered at all. So the post office doesn't seem to be, based on my anecdotal observation, working in the way that it would normally be. But we assume that when the clerk's office reopens, any mail that hasn't been delivered will be delivered to the tax court. So what our advice is, the best practice is, if you're going to mail a petition, you should do it well in advance of the due date and keep proof of mailing. Certified mail, United States Postal Service certified mail is the best method. Get that stamped at the post office. The other tidbits that you should know is if you learn from the Goralnik case, if you're going to use a private delivery service, make sure it's one that is approved. And the other thing that's happened to me so far twice in my career is once after 9/11, where there was an extension under 7508 Cap A, I did get a motion to dismiss, and now you would say to yourself, well, didn't the IRS lawyer know that 9/11 happened and that there was an extension? And you would think that they did, but they actually didn't. And if I hadn't really looked into it and done the research and realized that there was an extension there, the case would have been dismissed. And it happened again to me last year when the clerk's office was closed due to the government shutdown in December and January of 2018. So just because I'm sure the IRS counsel people they understand these rules and they're not going to be filing motion to dismiss, but that doesn't mean that something might slip through or somebody might just forget and a motion will get filed. So just remember to just pay attention to these rules if you have clients coming in after the fact.
And this is Sheri. I would just like to also add, of course, also if you fell into that period before the tax court clerk's office had closed, you might keep in mind, again, this new provision, Section 7508A, paragraph D, and the mandatory extension that could be provided beginning January 20th. And since we don't yet know when the disaster ends, we don't have an end date. Everyone should, of course, look into this and use it with caution. But if a deadline had passed, it might be a tool to put in your toolkit and look into to see if that would help solve your problem.
Well, we have two examples dealing with the interplay of 2023 and Goralnik. And the first example dealt with a time when the petition ended before 2023 came into existence, and there you'd be relying solely on Goralnik. And the second one deals with when they're both at play. So we've covered both of those situations, and and the Q&A that the government just issued is important, saying that the government agrees with the application of the time extension from Goralnik into 2020-23. Elizabeth alluded to what happened in the government shutdown of 2018, but I thought I would bring it back for Drita to talk about that shutdown a little bit.
All right. Thanks, Keith. And as Elizabeth noted, based on her experience, and of course she was a docket attorney in the Manhattan office at the start of her career, there may have been instances where our folks did not know our position on Goralnik, and so may have filed motions to dismiss based on a arithmetic calculation of the time period. And so as a result, the court issued the orders that are highlighted here in this slide. But I think it's really important to note that we obviously litigated Goralnik. We were surprised with the outcome, and I thought the court did equity in that case and appropriately applied the federal rules of civil procedure. It was not an argument that we thought applied or even anticipated, but thankfully, because of the hard work of the Harvard Law Clinic, Keith and Carlton, and the amicus brief that was filed for the court, in our view, got it right. And so we did not appeal Goralnik. We haven't issued any kind of acquiescence. And so for the folks in the field, it was left to them to coordinate appropriately with the national office to know that we had affirmatively not appealed Goralnik. There wasn't anything that they could turn to that said, we agreed with the results of Goralnik. So I can see why that may have happened, but I think as we identified these cases, once they were coordinated, we rightfully conceded the jurisdictional issue was not a problem.
Yeah, just to add, after when I had the experience after 9/11 deadlines that were extended, all I really had to do was point out the existence of the notice that was in effect at that time, and it got resolved. But I'm just saying, like, it's not always like you said, it's not always the first thing on everyone's mind when they're getting to their cases and working their cases.
Right. Okay, so Keith, if you can advance to the next slide.
Hey, Carl, you're going to take over from here and talk about jurisdiction and equitable tolling?
Yep. So first I want to make a slight correction to what Drita just said. The Harvard Clinic did not urge the position that the court ultimately adopted in Goralnik, which was that where it borrowed the rules on the availability of the clerk's office that under Federal Rules of Civil Procedure 6. What we had argued in our amicus brief for the Harvard Clinic was that the tax court should reject all of its 100 years or almost 100 years of precedent and declare that the filing deadline in the tax court is not jurisdictional, is subject to equitable tolling under recent Supreme Court non-tax case law that started up in 2004 and that generally had not been subject to discussion in the tax court or the appellate courts since 2004. But let's go through an example of equitable tolling. And first, what is equitable tolling? Equitable tolling is a doctrine that arose under common law, where judges using their equity hats would say, looks like you had a great reason for missing the statute of limitations. In bringing the suit, I'll let you bring the suit. There were several grounds for equitable tolling, but the most common one was where circumstances beyond the plaintiff's control prevented the timely filing. And as long as the plaintiff could show that they were reasonably diligent, that they could get equitable tolling, and which would allow their complaint to be treated as timely. On slide 11 that we're looking at, we have an example here of a statutory notice of deficiency issued December 16, 2019, which would mean that the last date to file a petition is Monday, March 16, which now, but hold on a second, Monday, March 16th is before the tax court clerk's office is closed, and is also before the April 1 deadline the April 1 date that begins the notice 2020-23 period extension. So this person who had to file by March 16th has no extension available unless 7508 Cap A subsection D applies, which I'm not going to discuss right now. So if you have a person like this, let's see, we'll continue our example. The taxpayer contracted COVID on March 8th, 8 days before the petition was due, ends up in the hospital on a respirator, gets out of the hospital, goes to rehab, finally mails the tax court petition on April 16th. But the petition is late, and no extension applies without considering the subsection D possible extension. So the tax court, as part of its holding in Goralick, would say we're sticking with our view that filing deadlines are jurisdictional in the tax court. And so, but before I get to what the word jurisdictional means, let me mention that there has already been one case involving equitable tolling in the tax area that was decided by the Supreme Court in 1997. It's shown on the slide, United States versus Brockamp. That was a case involving the refund claim, administrative refund claim filing deadline. The court there held that the refund claim filing deadline was not subject to equitable tolling, and the court gave around 5 reasons why, among them that there were many other statutory exceptions to the 2 or 3 year filing period in 6511A, the administrative nightmare that would be caused by this because there are millions of returns filed each year claiming refunds, almost 100 million maybe at the time. The 6511B look back period was unlike anything which deals with the amount paid within the look back period. There's nothing like that anyone could identify in any other statute that had been equitably tolled. So the Supreme Court said no equitable tolling of the 6511 filing deadline. That was not a case involving tax court filings. But the government took the position and has taken the position ever since that Brockamp really applies to any filing in a court in tax cases, of any kind of tax case. And it's still taking that position. So now, I mentioned the word jurisdictional, though. What does jurisdictional mean? In 2004, Supreme Court said, we and lower courts have overused the word jurisdictional. We use it anytime someone seems not to meet some requirement. But the Supreme Court said that we shouldn't be using the word jurisdictional for claims processing rules. We should only use jurisdictional, and for henceforth, we're going to only use it for subject matter and personal jurisdiction, not claims processing rules. And in a later case, the Supreme Court said, by the way, the filing deadlines are the quintessential claims processing rule. So why does it matter whether a deadline is, quote, jurisdictional? If a deadline is jurisdictional, a court has to police it because the parties can't stipulate the court into jurisdiction. The parties can't waive it. It can't forfeit the argument. No party can be stopped, and there can't be equitable tolling if a time period is jurisdictional. So that's the first. If you wanted to argue that in our example here, this person had a wonderful reason for not being able to file on time, and they were diligent. They got out of the hospital. They quickly filed a tax court petition. That sounds like good grounds for equitable tolling. And I imagine that there are going to be a lot of state courts in all sorts of other suits that are going to say COVID-19 was a great excuse if you're in the hospital for equitable tolling. So, but to win equitable tolling at the federal level, you're going to have to prove two things. First, that a filing deadline is not jurisdictional, because if it is jurisdictional, there can never be equitable tolling. Second, you're also going to have to say, even if the filing deadline is not jurisdictional, is it subject to equitable tolling? Because you can have a situation, and the Supreme Court has had this, where it said this particular statute isn't jurisdictional, but we don't think it should be subject to equitable tolling. That's a Medicare case called Auburn Regional Medical Center from 2013. So in 1990, though, the Supreme Court, in a case named Irwin v. Department of Veterans Affairs, held there's a rebuttable presumption that non-jurisdictional statutes of limitations applicable to suits involving the federal government are subject to equitable tolling. Brockamp, which was decided 7 years later, is simply a case where the Supreme Court said that the Irwin presumption hadn't been rebutted. Now, I mentioned that starting in 2004, the Supreme Court has changed what the word jurisdictional means. So let's talk about prior to 2004 and tax court filing deadlines. And let's think about the tax court has about 20 jurisdictions, but I'm going to mention only 4 today. I'll mention innocent spouse, collection due process, whistleblower jurisdiction, and the deficiency jurisdiction, which is by far the biggest. Prior to 2004, the tax court had taken the position that all petition filing deadlines, whether under its deficiency or any other its jurisdiction, are jurisdictional. So the deadlines can't be equitably tolled. And every appellate court had a case involving the deficiency jurisdiction before 2004 and agreed and said, yeah, the tax court filing deadline for deficiencies is jurisdictional. Prior to 2004, no appellate court disagreed with respect to any of the other tax court jurisdictions, like collection due process or innocent spouse. But not all courts reached the issue of whether a filing deadline is jurisdictional under, say, innocent spouse or collection due process. So I can't, unlike deficiency, where every circuit said the tax court filing deadline is jurisdictional, for these other jurisdictions, they're spotty case law, but it was all consistent in the appellate courts that if the issue did come up, they agreed with the tax court. So we now have this new rule from a case, a 2004 case named Contract v. Ryan, that says that generally filing deadlines are never jurisdictional anymore. The complete opposite. And so what are the rules under the new Supreme Court authority? And by the way, there's a case decided out of the Supreme Court almost every term since 2004 on this issue. They're not tax cases, but they are other cases, and appellate judges certainly know about these cases. So there are 2 exceptions to the rule that henceforward filing deadlines aren't jurisdictional. First, if there's a long line of Supreme Court opinions holding a filing deadline jurisdictional, the court will stay with that long line under Starry Decisis, assuming that Congress read the Supreme Court opinion and didn't change the law. Now, there never has been a Supreme Court case involving whether a tax court filing deadline is jurisdictional, so this long line of Supreme Court case exceptions shouldn't apply, we argue, to interpreting any tax court filing deadline. There's also an exception called the clear statement exception. The Supreme Court said that if Congress wants to, obviously it can make a filing deadline jurisdictional, but it has to make a very clear statement to that effect, because making something jurisdictional is kind of tough. It makes the courts police it. It causes all sorts of problems. After you go through a trial, somebody could raise a jurisdictional objection and the whole trial could get tossed out. The Supreme Court said there are good reasons why filing deadlines shouldn't be jurisdictional. So the presumption is they're not. But Congress can override that presumption, making a clear statement. But in the 2015 case involving the Federal Tort Claims Act named Wong, Congress said, quote, Congress must do something special beyond setting an exception-free deadline to tag a statute of limitations as jurisdictional and so prohibit a court from tolling it. Now, since 2004, this clear statement exception, the Supreme Court hasn't yet held any filing deadline or any other claims processing rule jurisdictional under this clear statement exception. So this puts courts in a tough position. The Supreme Court has articulated an exception that it has never used. So it's hard to see which way the courts of appeals have a hard time saying, is this a clear statement or is this not? Because there's never been a Supreme Court case that said, oh, this is here, the clear statement exception applies. Now, I want to talk about the 4 tax court jurisdictions that I mentioned and what case law has come out, because particularly at the impetus of Keith and me, we have been pushing the courts to actually address this recent Supreme Court case law on what is jurisdictional and also equitable tolling, and apply it in the tax area. The first time the tax court ever applied this Supreme Court case law was in the 2009 opinion in Pollock, which was an innocent spouse case. And there the court, essentially applying the clear statement exception, said, look, the sentence that contains the filing deadline in 6015E also contains a parenthetical giving the tax court jurisdiction, quote, if, unquote, the filing deadline is made within a 90-day period. So they said, well, that's a clear enough statement. It says, you have jurisdiction if the filing is made within the period. 3 circuit courts have since, Pollock was appealed, but the IRS gave up trying to collect the money, so the case became moot. There were 3 other cases, though, in which the Harvard Clinic represented taxpayers in 2017 and 2018 in the 2nd, 3rd, and 4th Circuit, where the court said, we agree the clear statement exception applies here, and this filing deadline is still jurisdictional. Let's talk about the collection due process filing deadline. We've talked about Goralnik. That's where the Harvard Clinic came in and filed an amicus brief saying this filing deadline, the collection due process filing deadline, is not jurisdictional and is subject to equitable tolling. The tax court unanimously rejected this argument, and we lost, I don't know, 15 or 16 to nothing. That doesn't mean it's a terrible argument. It means that I think it was a new argument, but the courts the tax court judges were very reluctant, and they said part of their reluctance is they think the clear statement exception applies, but they also said, look, Starry Decisis would apply, and they cited all their prior tax court cases. Query, though, can tax court cases meet the requirement for the Starry Decisis exception to the Supreme Court? Because tax court opinions are not Supreme Court opinions. So in Goralnik, though, they're interpreting 6330D1, which is a jurisdictional grant for CDP, and the tax court said, look, the clear statement exception applies because the filing deadline is contained in the same sentence as the jurisdictional grant. And what have the courts of appeals said? Only one court of appeals has actually decided this issue since the tax court's ruling in Goralnik. The 9th Circuit in a 2018 case named Duggan agreed with the tax court that the 30-day filing deadline in 6330D1 is jurisdictional under the clear statement exception. The court said the filing deadline is in the same sentence as the jurisdictional grant. They're made within the same breath, the court said. But no other circuit has ruled on the collection due process filing deadline and its interaction with the Supreme Court. Yep.
Carlton, my recollection is that Goralnik, the opinion did have a string cite to different circuits that have agreed with the tax court prior to.
That's true. The tax court said, that's true. And actually, the tax court cited not just collection due process cases, but its own deficiency jurisdiction.
Sure.
It's absolutely clear that there is plenty of precedent, especially under deficiency jurisdiction, that these filing deadlines are jurisdictional. But those cases before 2004 never considered the new Supreme Court thinking on what is jurisdictional. And so that's why we're having this argument now over, well, is the filing deadline jurisdictional, since the Supreme Court has changed to the rule being that filing deadlines are almost never jurisdictional. Now, I have to say, the government takes the position that in the litigations that are happening currently in the circuit courts, that federal court, that tax court and circuit court precedent is relevant to to creating this exception for stare decisis. I believe if you read the most recent Supreme Court case law, including one written unanimously from Justice Ginsburg about a year ago, that it's only Supreme Court opinions that allow a stare decisis exception to the jurisdictional, to the non-jurisdictional nature of filing deadlines these days. But so getting back to it, so the Ninth Circuit has said, we've looked at the recent Supreme Court case law and we agree with the tax court, and we think that still this is a jurisdictional filing deadline. So that's the first court that has actually ruled on the issue and in CDP. There is another case pending at the moment in the Eighth Circuit named Boechler, Boechler, that presents this issue. So there's a possibility that courts might disagree. Why might they disagree? In part, well, now I'm going to get to the whistleblower award jurisdiction. The whistleblower award jurisdiction is just like CDP there's a 30-day period to file a tax court petition. It's at 7623B4. That language in 7623B4 was taken almost verbatim from the CDP filing deadline at section 6330D1. There's a jurisdictional grant within a parenthetical, and then that follows the mention of the filing deadline. In a case named Myers, first off, I should say, all appeals in whistleblower cases go to the D.C. Circuit. They don't go to the regional circuits. They all go to the D.C. Circuit. This is a special rule under the venue on appeal rules, is 7482B. So there was a person who filed, Mr. Myers, who filed late in the tax court. And among the things he argued on appeal in the D.C. Circuit was that the filing deadline wasn't jurisdictional. Equitable tolling should apply, and he has good facts for equitable tolling. The tax court said the filing deadline is jurisdictional, and there's no equitable tolling. But in Myers, in the D.C. Circuit last summer, the D.C. Circuit said, look, we realize 7623B4 is similar to 6330D1, the CDP filing deadline. And we realize that, yes, the filing deadline is in the same sentence as the jurisdictional grant. But the court said, we think the jurisdictional grant related to the subject matter and not to the filing deadline. And so that this was not a clear enough statement that the filing deadline is jurisdictional. So the D.C. Circuit disagreed with the Ninth Circuit in its CDP holding and with the tax court in Geraldic, and said that the filing deadline for the whistleblower award isn't jurisdictional. And then the court went on and said, and just because Brockham held that particular statute of limitations was not subject to equitable tolling at 6511, that doesn't govern 7623B4, and the normal rule is that statutes of limitations are subject to equitable tolling, and we apply that here. So the tax court has to follow under Golson the ruling of Myers. So if you have a whistleblower award case, you don't have to probably rely on any exception or any notice or the Geraldic case you can rely on the D.C. Circuit's opinion in Myers, but that's only one jurisdiction for a relatively small number of cases, maybe 100 cases in the tax court each year. But the taxpayer in that Eighth Circuit case, Bechler, that I mentioned, that's a CDP case, is asking the Eighth Circuit to essentially follow Myers, hold the filing period not jurisdictional and subject to equitable tolling, and not to follow the Ninth Circuit's opinion in Duggan. Now I want to finally move on to the deficiency jurisdiction filing deadline. What's surprising is that in 2004, the Supreme Court changed the rules on what normally is a jurisdictional time period. There is no, subject to comments made in Goralnik, which was really a CDP case, there is no case yet that has analyzed whether the 90-day period to file under Section 6213A is still jurisdictional, or instead whether it's subject to equitable tolling under the recent Supreme Court case law. So, and there are good arguments either way on this one. If you look at 6214, is where the jurisdictional grant is in the tax court. It's not in the sentence that gives the 90-day period. So this issue has been litigated. The interplay of 6213A and jurisdiction has been, under the recent Supreme Court case law, has been litigated only in one circuit court explicitly, in the Seventh Circuit in Tilden, which upheld the tax court's holding that the time filing deadline is jurisdictional. And there's an unpublished 2019 Third Circuit opinion in Garrett where the Third Circuit agreed. But none of the other circuits have yet ruled on the issue of the interplay of the Supreme Court case law on the deficiency filing deadline. So it's an open question. There are two companion cases currently pending in the Ninth Circuit, organic cannabis and Northern California small business assistance. There are two marijuana dispensaries who filed, sort of similar to a Goralnik situation. Those cases were argued on October 22nd. It's been 6 months. There's no opinion yet. So the issue of whether a particular collection due process or deficiency filing deadline can be equitably tolled under recent Supreme Court case law is actually one that's rather open in a number of places. Two final thoughts, and I'll get off very quick. Before going down the road of arguing that the deficiency filing deadline is now subject to equitable tolling, remember that winning that issue will likely involve a trip to the Supreme Court in the absence of a legislative clarification. So consider, before you get through, try to use equitable tolling, abandoning any late filed tax court case if you think that you can solve the problem after assessment by either audit reconsideration, paying and suing for refund, or an offering compromise. Second, if you do decide to go down this equitable tolling route, which you only do if you have to because none of the other exceptions apply, then please contact Keith or me about the case, because we're trying to kind of coordinate or be aware of every case in this area, and we might even want to file an amicus brief in your case. That's it. Keith?
Okay, thanks, Carl. Did you want to talk a little bit about refund jurisdiction while we have you?
Well, that's be quick. It's important to know that Notice 2020-23 also extends the period to file a refund claim under 6511A. Also, the look-back period under 6511B, the amount paid, is similarly extended. That's, if you look at the regulations under 7508 Cap A, you can see an example where they say an extension under A also extends under B, the payment amount period. Also, the extension by the notice extends the filing deadline in district court for a refund lawsuit. That's at 6532A, the 2 years after the disallowance of the claim. is suspended by the notice. So I just wanted to you can look to that area. You can also argue perhaps the 6532A period is subject to equitable tolling if you can't, if you don't fall within the notice postponement, and there's almost no authority on whether there actually has been no ruling since 2004 on whether the 6532A filing deadline is jurisdictional. That's it.
Okay, thanks, Carl. Now, Sheri, you want to talk about thoughts on whether there's some legislation that might make a difference here?
Sure. I think one of the things that anyone's been listening can observe pretty easily is that from our conversation today is that perhaps a legislative solution is needed. In fact, I think I would argue that a legislation solution is strongly needed. Having to rely on piecing together Juralnik plus the IRS's exercise of authority and Notice 2020-23, as the examples provided show, that won't solve every problem. And if we have to then turn to, well, we have a new statute, 7508 Cap A, paragraph D, does the mandatory extension apply? Well, if we're not in if we're not in a situation where we've had a declaration to which a disaster occurred, that has limited application. And as Carl just explained to us, that equitable tolling, while it seems like it's the right answer, that case has not yet come up before the Supreme Court where anyone would be confident on it. And in any event, we all know that litigation takes a very long time. And I think one of the things that we've all seen from the past few years is we have recurring concerns as far as what happens when you're not able to make a deadline. We've seen government shutdowns, we've seen snowstorms, we've seen what appeared to be road closures that did not qualify for a Juralnik exception. And now we have a worldwide pandemic. So who knows when the next type of situation will be before us, but it certainly seems that without equitable tolling, we end up often with overly harsh results. That tax court, as we know, is our only prepayment forum, and sometimes it's our only forum. So trying to make sure that there's an opportunity there that isn't relying on all these tools, but instead can point to a statute is and indeed would, I think, be welcome to the tax community. That folks have raised questions as to whether that would be open to abuse, and I think there'd have to be, a good cause or some type of standard, and other, as Carl has mentioned, that lots of statutes of limitations are not jurisdictional, and the courts are able to manage that. And I think as long as you have a good cause, you were, with the example, in the hospital with coronavirus. If that isn't good cause, I don't know what else would be. So what would a legislative solution look like? Well, there are different ways that it could happen. You could amend Section 7422 and all the relevant individual code sections. You could also pass a new global section, enact a new code section that would provide for periods, would provide specifically that periods for filing suit, refund, etc., are not jurisdictional and are subject to tolling, whether it be equitable tolling, waiver, estoppel, or forfeiture. Again, including a good cause standard would protect the interests of the government. We all need statutes of limitations. They're important. Taxpayers, should follow their obligations as well as the government. And so it wouldn't be just, the wild, wild west out there. And again, the IRS would still be able to raise this as untimely, and the courts could still dismiss. So it seems like it would be a sensible and opportune time for Congress to act on this, and I'm hopeful that they will. We know the National Taxpayer Advocate has made this a part of her report, and probably Keith or Carl can correct me if I'm wrong, but it seems like it's been at least the last 5 years, maybe perhaps not quite that long, but I know it's been a recommendation of the National Taxpayer Advocate. Along with amending the relevant those sections, we would also need to amend Section 7459D, making clear that late filed claims would, since they would no longer be dismissed for lack of jurisdiction, this would mean that the taxpayer would still have a right to, they would have to clarify, would still have a right to pursue a refund suit. That since late filed claims not dismissed, as untimely, we would just need to make sure that we clarified 7459D to clarify that dismissal is not a decision on the merits, and that there would be no entry of decision reflecting deficiency. Therefore, we would be able to allow refund suits. But I think the biggest part of today that folks should come away with is that perhaps the time has come where a legislative solution would be certainly far quicker than litigation, and certainly far more certain than having to cobble together 3 or 4 different doctrines to get to what I think everyone would agree is the right result.
So this is Drita, Keith, and Sheri. I've been silent because obviously the jurisdictional issue and equitable tolling is one that's pending in litigation, and we don't comment while that is occurring. As it relates to any legislative proposal, obviously that would be for Treasury to do. But the one caveat I would caution is, jurisdictional arguments can be raised at any time. But once you remove the jurisdictional out of the timing, then it becomes an affirmative defense that has to be raised and is waived if not timely raised. So that would be my only caveat as you go down this road.
This is Carl, and I don't disagree with Drita. It's very important. But actually, one of the benefits, not necessarily of equitable tolling, to taxpayers of not having the filing deadline jurisdictional is that, yes, if the IRS didn't raise untimely filing as an affirmative defense, the issue would be waived. Just like this happens in litigation in all sorts in state courts and all sorts of other areas, and yet the law survives. The primary beneficiary of calling the tax court filing deadline non-jurisdictional would actually not be the rare person who gets equitable tolling, but will be many, many times, about 7 or 8 times a month, at least by my research, the tax court judge stumbles across a case where he or she thinks the petition was filed late and issues an order to show cause asking the parties to discuss the issue. The tax court has to do that because it has to police its jurisdiction. If the filing deadline were not jurisdictional and the IRS just missed it like it did in all these cases, 7 or 8 a month, then the tax court wouldn't police and wouldn't issue an order. And so 7 or 8 people would slip through each month, even who didn't have a good excuse necessarily. But that's simply a matter of litigation between, the plaintiff and defendant, and the defendant has to raise affirmative defenses. So I think it's a pro-taxpayer version, but but it might cost the government some money in cases where the government forgot to notice that a filing was late.
So with respect to equitable tolling, though, it would have to be timely raised and supported, obviously.
Yeah, I would think that a person would raise equitable tolling, if we get this far. The government will raise late filing as an affirmative defense, usually in in paragraph number 7 of the petition. The taxpayer will file a reply saying, yes, I filed late, but I deserve equitable tolling because of these following facts. So it'll be kind of like in a fraud case where the government comes and says, well, I know we issued the notice of deficiency more than 3 years, but there was fraud here, and they say that in as an affirmative defense in the petition, in the answer, and then taxpayers would file a reply saying there isn't any fraud, and I deny all the facts that were alleged in the other one. But equitable tolling would be also an affirmative defense by taxpayers. So both the taxpayer would have to say, yeah, I claim equitable tolling after the government said you filed late.
Carl, in the example in the slides, we had an example of somebody who was sick because of COVID. What are traditional bases for equitable tolling that the courts have recognized?
Well, as I said, the most common one, which is fairly broad, is that circumstances beyond the taxpayer's control prevented timely filing. But the taxpayer, was diligent anyway. So basically, things outside the taxpayer's control. So it can't be that the taxpayer said, "Gee, I was busy working, my regular job, and I didn't have time to file." I would think that most of the issues that come up in a reasonable cause for late filing penalty issue are going to be similarly grounds for equitable tolling, like death in the family, illness. So that's one common situation, circumstances beyond the taxpayer's control. Secondly, if the defendant actively misleads the plaintiff as to the filing deadline, that's another ground for equitable tolling. That's going to be a very rare one. It's basically estoppel, saying the government did something to trick me into filing late. But it could happen, and we actually argued that in some cases, but didn't win those cases yet. A third one, which is something that Keith and I are litigating, is that, as you know now, when people get a notice of deficiency, they often don't, and they want to contest it. The notice of deficiency file in the tax court. But some people, and there's a certain percentage, who always, what they do is they either write the IRS office that issued the notice of deficiency, or they send a tax court petition to that IRS office that issued the notice of deficiency. A third common ground of equitable tolling is timely filing in the wrong forum. And equitable tolling exists right now with veterans benefits. If you want to go to the Court of Appeals for Veterans Claims, which is an Article I court, what happens often is that people get denied veterans benefits, and rather than file their petition or complaint, whatever it's called, in the Court of Appeals for Veterans Claims, they send it to the Veterans Department office that issued the denial. That's the wrong place. But the Federal Circuit, which hears appeals from the Court of Appeals for Veterans Claims, has held that that's good enough. That's timely filing in the wrong forum. So I would think that there will be some people also who benefit, who actually get their petition back to the IRS. Some people actually will fill out the Form 2 petition and mail it to the IRS. So I'm not talking about people who write to the IRS and are still trying to convince the IRS that they were right, but people who thought they were petitioning the tax court, but thought mistakenly, even if obviously mistakenly, that they sent it to the IRS office rather than the tax court. And we are currently litigating one of those cases. We're looking for other test cases. They come up with fair regularity, actually.
Okay. Thank you, Carl. I wanted to ask Elizabeth a practical question. Suppose you have a petition that's falling due. Let's say the 90th day is today, April 29th, and you know from your answers before, we know that you have until July 15th to file the petition in tax court. What are you doing with that case? When are you planning to file the petition, and how are you planning to file it?
Okay, well, just one of my practices is always try not to do anything on the very last day. In case you screw it up, then you still have the last day to fix it. But I feel like there's really sort of a a few things you can do. One is you can use an approved private delivery service, and those are listed actually on irs.gov. So you can actually just put in their search site private delivery service, and the approved ones will come up on a page, and it actually just got updated last week. You can use certified mail, which there's an abundance of tax court cases that say certified mail is okay. When I use a private delivery service or certified mail, I then go back and find the tracking information and print it and save it as a PDF with my petition, so that if anything ever comes up in the future, I can show that tracking information to a court. Now, sometimes tracking information will fall off the USPS system, so you don't want to find like a year later you're going back and trying to track something and you can't find the tracking. So right after we mail stuff and right after it gets delivered, we save the tracking information. So it's certified.
Can I add, Elizabeth?
Yeah, sure.
That's not just for the post office. Tracking information, the cases that are being litigated out in the Ninth Circuit over whether the deficiency jurisdiction filing deadline is jurisdictional. There's a situation there where the IRS, about a year into the tax court case, said, "Oh, you file late," and the taxpayer said, "But I filed using FedEx first overnight," and this is again before FedEx first overnight was approved, and there is no longer any FedEx information. The IRS raised the issue more than 6 months after the case started, and FedEx had wiped its records of the reason why the package wasn't delivered on time to the tax court. So if you're using a private delivery service, get that tracking information as well.
And get it saved and printed or saved as a PDF on your file. And the fact, if you're using an approved private delivery service or the post office, the fact just that you mailed it, right, is going to be enough that you mailed it on time. And then I always go back. I have my students go back after it's been delivered and print that again and save that again. Again, certified mail is expensive. People maybe don't want to go to the post office right now because they don't want to be exposed to the virus or people who may have the virus. I always tell my students that the poor man's method to this is to pull out your phone, make sure the time and date stamp is activated, and take a picture of yourself at the mailbox with the envelope, go to the tax court. Now, I realize there's been no tax court cases about that, but I think with, oral testimony, that would make that picture admissible, that you might, it might be okay. And I also want to point out, so that's my best practices. That's what we do. That's what I would do now. I would I'm trying to file everything still, timely or before July 15th if we can. I do want to point out I have an innocent spouse case right now that we are going to not file within the normal time frame. We're going to wait because she can't move out of her house. And we're hoping that she'll be able to move out between now and July 15th, and that on July 15th we'll be able to file. And then because obviously right after we file, the non-requesting spouse is going to get an intervener notification from the IRS, and we don't want that to happen while she's still living in the household. So those are my methods. The other thing about the Postal Service is you can get a proof of mailing slip again for $1.50. And again, that's not trackable, so that's maybe not the best way, but it is cheaper than certified mail. And as far as tracking services go, with the Postal Service, the cheapest tracking method is basically like about $3.50.
Uh-huh. So, Elizabeth, I'm not sure I have all the facts from what you described, as with the picture of the post office, et cetera. So I would just caution you that the IRS does not agree that extrinsic evidence is good evidence of the proof of mailing.
Well,
there were regulations.
You'll never have to come up at court, but I think that I don't know what to say to people who are really afraid to go to the post office or UPS. I think then you're just going to have to wait until a time is comfortable. You're comfortable going and doing the mailing for your client.
Right.
I think Drita had raised a very good point that there's the regs and there's case law that would ordinarily make that not the best practice. Whether the times will make the courts feel a little more comfortable with that, I don't I don't know. Sheri, we had a question from somebody who said, can you file a motion for leave to file a petition late and ask the court to lodge the petition? Have you ever done that or heard of that?
I have not done that, and I would not think that that would work, given the court thinks that, that filing petitions is jurisdictional. So I would caution anyone against doing that. I don't know if anyone has a different view, but I would think that would not be sufficient, and it would be untimely, and that would, under current law, under the tax court's current holdings, that would trigger a decision on the merits if you were late. Now, if you did it in plenty of time and wanted to see what the court's response would be, as long as you allowed yourself time to timely file a petition, then you wouldn't be in bad shape. But I don't think it would get you anywhere, and you'd be better off just filing the petition.
I certainly agree with that. I don't know if anybody else wants to comment. I mean, at best, if you filed such a motion and it was near the end, you'd hope they would treat it as an imperfect petition, but the better practice would be just to file the petition. Drita, we drew a question. I'm gonna toss to you, but toss it back at the rest of us. But it's really not a tax court jurisdiction question. It's a notice 2020-23 question. But the person asking the question says that appeals requires 270 days remaining on the estate tax statute limitations in order to go to appeals, and that 270-day period is going to expire in mid-May. Will this person still get a chance to go to appeals, even though by the time the government reopens, it'll be less than 270 days left on the estate tax statute of limitations? Do you have an opinion on that? I know that you may not.
Yeah. So the notice does provide for some enlargement of time for the Government Act. And what it says is if the date for performance is on or after April 6th and before July 15th, the IRS gets the benefit of an extra 30 days postponement. And it specifically mentions cases that are under examination, or this is not a case that's before appeals, but it also covers cases that are before appeals. So, I think that period is postponed as well.
Okay. Thank you very much. Elizabeth, we have a case, or maybe a comment, but to be careful with certified mail. If a signature is required, it might get returned because nobody's at the tax court to sign it. Can you respond to that?
Yeah, and I think, private delivery services, it might get returned too. I just think you have to keep proof of mailing and then either resend it to the tax court. If it gets returned to you, mail it back, or wait till the clerk's office opens and mail it back. I'd love to hear what other people think, but if your FedEx gets returned, or your certified mail gets returned, I think the best thing is to keep all of that proof still, and then I think when the clerk's office opens, to send it back, or maybe that's what I would do, but I'd like to hear what everyone else thinks.
I think based on what happened in the government shutdown, of course it was a shorter time period, but that if you use the Postal Service, the Postal Service is holding the tax court to mail and didn't normally send it back. I can't say that they never sent it back. So they would hold it, and then at some point when the clerk's office opened, a huge amount of mail came into the clerk's office. If you use a private delivery service, there were some cases where it did kind of come back to the taxpayer or end up in a funny place. So it looked like using the U.S. Postal Service was a little bit safer in the government shutdown than using the private delivery service. Of course, in both instances, you'd want to keep good records. We drew another Postal Service question. Elizabeth, I'll toss it to you as well. Is the U.S. Postal Service priority mail, which has tracking, is that sufficient?
I think all U.S. Postal Service is sufficient, but I think the tracking gives you the ability, right, to show when it was mailed, the day it was mailed. It will show up. You'll have a stamped receipt with a date on it. So you keep the stamped receipt. The tracking information will show when it's mailed, and eventually, hopefully, it will show that it was delivered.
This is Carl. Let me just add a couple things about 7502, the timely mailing is timely filing rule. 7502F, which deals with the designated private delivery services, says that the date that it appears in the records of the private delivery service is treated as the date of mailing. So tracking information is ideal if you're using, let's say, a FedEx. The rules for regular mail or for the U.S. Postal Service are much more elaborate and are way beyond the scope of what we can deal with in this call. But generally, the rule is that something, if you don't use certified or registered mail, you use regular mail, the date of the postmark is treated as the date of mailing, which means, unfortunately, that if you drop something in a mailbox at 11 p.m. one night and the next morning the Postal Service picks it up and postmarks it, that's treated as late. And the courts have said that they can't accept parallel evidence that you mailed it earlier. The regulations, both the regulations and 7502 say that if you use certified or registered mail, the date stamped by the Postal Service on the receipt is proof of mailing. We're talking about the white receipt, not the green return receipt. A return receipt requested actually doesn't have any effect over the tax code's jurisdiction. It's the white receipt. The date stamped on the white receipt for certified mail by the post office, not your in-house mailing room, but by the post office. The date stamped on certified mail receipt is deemed to be the date of mailing, regardless of whatever happens to the envelope later.
Okay. Thanks, Carl. I have a question. Drita or Sheri, I'm going to toss this to you because I know you recently met with the court, but do you think that what's happening here and what happened in the government shutdown is going to change the court's practice regarding electronic filing of petitions? Do you think that's coming soon, and that'll change some of the discourse here?
Starry, do you want to?
Sure. I know the tax court is looking at it and looking at updating a lot of its practices and procedures. One thing we also know and that we've heard various of the judges speak about is a concern that most petitions received are from unrepresented taxpayers. And between that group of taxpayers as well as taxpayers who are represented, there's a really bizarrely high percentage rate of petitions with notices of deficiency and whatnot attached that reveal identifying information that could lead to identity fraud and other sorts of problems. And so the tax court has been weighing those interests against, obviously, access and ease, and I don't know where they'll end up. They've been trying to find a solution to that problem. But Drita, I don't know if you were at any of the presentations where it was mentioned just the very, very high rate of information that could easily be used by fraudsters to for identity theft purposes. And of course, once they know, petitions are up, electronic filing and perhaps publicly available more than they are now, that could cause real problems. But it also, my understanding is the tax court is working on their electronic systems overall, and that they have, it's apparently an incredible number of steps of processing that occur when a petition comes. And so trying to make all of their, various parts connect with one another, I think, has been another issue. So I'm not sure if we're going to see that, or maybe we will, but we'll see what happens. And the filing issue is different, obviously, than being publicly available and viewable, but I think they go a little bit hand in hand from what I've heard from the court. But again, that's my speculation and my reading tea leaves.
Mm-hmm. Yeah, the court is actively working to update its e-filing system, and we're working with them on that because obviously we've got to be able to interact with the court since we're the party on every case. With respect to petitions, I honestly don't know, and I do think the court is very concerned, and we are as well, about ID theft, as Sheri mentioned, because I think Judge Book has been on the record as saying, you know, there's a lot of sensitive information that is floating around in things that have already been filed and are out there. Folks just don't redact their documents well.
Yeah. Judge Book gave an excellent presentation at the last ABA meeting, and he allowed me to publish it, and all of his slides are in an article that I'm publishing in Tax Notes that will be out on Monday, May the 4th. So if you want to see just how bad both taxpayers and practitioners are at redacting the information, take a look at that article, and particularly the part that deals with Judge Book's research on redaction and meeting the rules of the court. So I have one.
I was just going to say, it doesn't help that the Social Security number's on every page, and sometimes it's embedded into the mailing, the return slips that you can pull off and mail back your responses either.
Yes, it's very. There are many places where the information shows up on the documents that get attached to the tax court. Drita, can you just say a brief word about what chief counsel attorneys are they working right now, and how do you reach them? What's going on in your office?
Yeah, so our folks, obviously there are the attorneys in the field as compared to the attorneys in the national office. Our field attorneys are actively working the cases that they have in their inventory, and there's plenty of it. They are reaching out to taxpayers, continuing to file motions, and, you know, continuing to do all the trial prep work that is necessary in cases. On the national office front, the pace for issuing guidance has actually increased, not gone down. You know, TCJA really ramped everything up, and now all this CARES Act and COVID legislation has ramped that up even more. So it's pretty impressive to see how engaged everybody is across the board.
So if you had a tax court case and you wanted to have a settlement conference with the chief counsel attorney today or next week, that's still a possibility?
Absolutely. We are open for business, available to talk about cases by phone. We have some video capacity with WebEx. We are doing a couple of virtual settlement days. So many of you may be familiar with settlement days, where we invited taxpayers to come in ahead of a calendar, month or two before calendar, to try to settle their case, maybe connect with an LITC clinic and or a pro bono attorney. And we are now exploring doing these virtually. Our first one will be in Detroit, May 9th. And then the next one after that will be in Atlanta, May 21st. So we're looking forward, number one, to doing it, and number two, learning how to better, provide virtual settlement days.
And how does a taxpayer or a representative get documents to the chief counsel attorneys in the field?
So in counsel, we're fortunate because we do have the ability to receive emails, provided we, follow our protocols for receiving email, and provided the taxpayer is aware that, when you transmit documents electronically, there is a risk that the documents will be, the information may be intercepted. But we are able to receive documents electronically, by fax, even by regular mail, because we do have people going into our offices periodically to check mail. But obviously, mail is the slowest method of communication these days, by a lot. for a variety of reasons.
All right. Did anybody have any other? We had a lot of questions came in regarding mail, and I'm not going to ask all of the questions. They get pretty far into the weeds, but I think it's clear from our discussion and certainly from looking at the questions and responses that we've received that being very careful as you mail your petition to the tax court is a critical piece of the puzzle. Did any of my panelists want to make any more comments regarding mailing before we move on?
Well, Keith, just one last thing on the mailing. I noticed a number of the questions have been quoting from the tax court website saying, if you send something by mail and it gets by mail or private delivery service and gets returned, keep the proof of mailing. In the last government shutdown a year ago, that happened. Some things got returned, and yet the IRS did move to dismiss for lack of jurisdiction in some cases. It may have been an accident, but when taxpayers came forward and introduced the proof that they had tried to mail during the shutdown, the court accepted that, even though the proof came into the tax court some days after the clerk's office reopened. So you don't have to get your proof to the tax court on the first day it reopened if you mailed during the period and it got returned.
Okay. Well, thank you, Carl. I think that's all the time we have for questions today. I want to thank everybody on the panel for great advice and preparation to speak today. And I want to thank all of our listeners. Thank you for joining us today, and we look forward to hearing from you after this if you have further questions. Bye.
Thank you, Keith.
Our faculty for this program: Elizabeth Maresca, Sheri Dillon, Drita Tonuzi, Carlton Smith, Keith Fogg. Thank you so much for sharing your expertise with us. On behalf of the ABA, thank you all for joining us. Before leaving, wait for the evaluation to come up on your screen. Thank you. On behalf of the American Bar Association and the ABA section of taxation, thank you for participating in this program. To learn more about the sponsors, visit the ABA website at www.americanbar.org. Thank you, and please click on the evaluation link. We value your feedback.